In a special session in May 2022, the Florida legislature passed SB 4D. This reacts to the Surfside tragedy by imposing more stringent safety requirements. One of those are the milestone engineering inspections and certain unwaivable reserves. But one unintended consequence of the new law, coupled with the real estate prices booming in our state, resulted in the increase in condominium terminations. We've all heard about developers who want to buy a condominium building, tear it down, and build a magnificent new condominium where an old one stood before. Those developers typically offer a significant amount of money over the market value. But remember, a condominium cannot just be sold by the board of directors. It requires a vote of the membership. The developer has to buy out the individual owners, and a vote of the owners is needed to kill off or terminate the existing condominium scheme. Chapter 718.117, Florida statutes, sets forth a very detailed process for a condominium termination. It must be approved by at least 80% of the owners and disapproved by not more than 5% of the owner votes. However, you can't just rely on the statute. You have to also look at your governing documents, because these might require a different level of approval. And sometimes the approval level in the governing documents is higher, and sometimes it's unanimous. So some associations amend the termination process in their governing documents to make it easier or to lower the threshold, because having a realistic voting threshold allows you the option of terminating if the right offer comes along. But this is referring to optional terminations. There is another termination form that exists in the state of Florida, and that is when damages to the building are significant and rise to the level of a large percentage of the property being destroyed. When that happens, and when property damages are excessive, the owners are able to vote on a plan of termination, which allows the owners to terminate the condominium scheme based on the significant level of damages occasioned by the casualty. However, this too involves a legal analysis, because you have to couple the state statute with the governing documents of the association. And just one final word of caution, and we see this every time there's a casualty in Florida. We've seen it with Hurricane Ian. There are some documents, mostly older ones, that contain a very tricky termination provision in the governing documents. There is a mandatory automatic termination if the property is damaged significantly enough that it triggers the automatic mandatory termination. That means that your condominium will terminate unless the owners meet and vote to not terminate it and to instead repair the damages to the condominium. So you really have to be very familiar with these condo terminations. And a lot of this conversation has been raised due to the application of the new law, because some associations simply don't want to incur the additional costs, and they get these attractive offers from the developers and they want to go ahead and sell. We've dealt with more condo terminations, I would say, over the past year than we have over all other years combined. It's something that is very hot, so to speak, on the market. So every association needs to familiarize itself with optional terminations or terminations due to significant property damage.